Hello, everyone, and welcome to day 3 of our live webinar on the new $100,000 H-1B proclamation. Today, I am joined by attorney Swapnali Kelkar from our Edison, New Jersey office and attorney Jioselin Juarez-Contreras from our headquarters in Los Angeles. Ladies, welcome to today. Thank you so much for taking the time to be here with us on this important topic.
Thank you.
Thank you, Arianna.
This conversation is for informational purposes only. If you have any questions, please comment them below and we will do our best to answer them. So Swapnali, I want to start by asking you a little bit about how this is going to be enforced. Can you tell us how might USCIS and the Department of State enforce compliance with the new $100,000 fee?
Yeah, sure. So as we know that the proclamation states that this fee is required to be paid at the time the employer is going to file any new petition post the effective date of this proclamation. So this is absolutely certain that if any employer is trying to file any new H-1B petition, then the USCIS will first try to make sure whether this petition falls within the ambit of this proclamation. And if it is so, then USCIS will certainly not adjudicate the petition unless and until the fee is paid. So that is the first step where USCIS will enforce this proclamation. And unless the employer is going to make the payment, USCIS most probably will not adjudicate that petition. Now, the second level of enforcement will take place at the time of issuance of visa at the consulate. So definitely when a petition which is falling within the ambit of the proclamation to which the rule is applicable, when somebody is trying to apply for a visa basis on such type of a petition, definitely at the consulate officer will certainly ask them to showcase the proof of payment of this 100K fee. So the compliance will happen at two levels. First at the USCIS, and when any employee will go for his visa stamping at the consulate.
Good to know. So what kind of record keeping would you recommend employers to maintain to demonstrate compliance with this? What are your suggestions here?
That's a good question because even though everybody is talking about the 100K fee rule, still there is no guidance from USCIS about how to make the payment of that 100K fee. We do not know where to make the payment, how to make the payment, what documentation USCIS may issue, or whether it is a bank statement which can be considered as a proof of payment of the fee. So there is no clear-cut guidance as such. But what I assume is whenever we are filing any petitions right now, and whatever fees we paid, whenever USCIS issues any receipt notice for any filing, the receipt notices always come with the amount of fee paid. So I'm not sure if USCIS is really thinking something like that when if any petition which is accompanied with the 100K fee, whether the USCIS is going to issue some kind of a receipt of confirming that yes, this employer has paid the 100K fee. But otherwise, I would say maybe the bank statement which can confirm that the employer has made the payment, and that's how employer can showcase the proof that he has made the fee payment. Apart from that, for other compliances, I would definitely suggest all the employers to maintain the PAF records, because there is another guidance which says that the Department of Labor is going to launch a project firewall where they are going to go behind the employers for their compliances. And one of the important compliance for every H-1B employer is maintaining PAF. So of course, employers must be maintaining their records for the 100K fee payment, as well as they must maintain their public access files.
Okay. And how does this apply at different posts? Like, could consular officers apply this rule differently at different posts?
I'm not sure. I don't think so that this will be applied differently, because ultimately every consulate officer has to interpret it in the same way. Maybe few consulate officers may ask for more proofs, or maybe may ask for more documentation, but throughout all the consulates, I assume that the rule will be applied in the same way, where they will ask for the proof if the petition is subjected to the proclamation. So definitely before issuing a visa, they will ask for the proof, but I'm a little bit skeptical whether it will be applied differently at different consular posts.
Okay, and can you tell us what would happen if, for example, maybe there was a payment error or a delay? What would that translate to?
If there is a payment delay or if there are any errors regarding the payment, it is likely that USCIS might reject the petition or may deny the petition or may issue an RFE asking for a proof of payment. So eventually when we will file such petitions, we will, I think, get to know more about it, or if USCIS releases any further guidance regarding this, we will get to know more about this.
Okay, wow, thank you for all of that information. Jioselin, I want to go over to you to talk a little bit about what this looks like from an employer point of view and the risks that they might be facing. So can you tell us a little bit about how this affects employers who place H-1B workers at third-party client sites?
Great question, Arianna. So the proclamation, like Swapnali was mentioning, it's a fee that's being paid for every new petition filed, right? So regardless if an employer is, filing a petition that's not a third party site, work site where the beneficiary will work at, they still have to pay the fee, right? But the main thing to consider is that, previously before this proclamation, there was already, a lot of scrutiny on third party site, basically applications. So something to consider potentially if, the viability of that employer will not be possible for the H-1B. Now with this fee is, maybe to explore alternative visa options for that employee, potentially, but also the fee, we don't exactly know, how to come about and if that could be used that money for like scrutiny on third party side. We don't really know that, but ultimately, it doesn't really matter the type of petition for each one. As long as it's a new petition, it's going to have that $100,000 KP.
Okay, and can you tell us what contractual issues employers should review in light of this new fee, if any?
Well, regardless, any employer should at any time always, consistently be reviewing their contracts. So I could think this is a good reminder for any employer to always have that constant review. But something to consider, similar to other fees for H-1B petitions, there's certain fees that cannot be paid by the employee that has to be paid by the H-1B employer sponsoring. So that's, again, make sure that your contracts do specifically state, payments cannot be paid by that employee being sponsored. So the 100,000 K will not be able to be paid by the employee. Would meet the company that's filing the H-1B themselves. That would need to pay that.
And should employers adjust long-term workforce strategies in response to this?
It's always a good thing to evaluate, potential long-term options, right? Because at this point, as Swapnali says, there is a little bit of things that are still unanswered for this proclamation. How does it look for specific, H-1B extensions, transfers, or everything like that, right? So, it's always a good thing to, explore long-term options, maybe green cards or alternative visa options, that the employee would qualify for. So yeah, that's a very good thing for the employer to consider that.
And what about this rule creating risks of discrimination in hiring? Could that be a potential thing that we need to look out for?
There's always a potential risk, right? With new changes that come up policy or proclamations, unintended consequences sometimes is that, you won't hire a certain person, something like that. So an employer wants to be very specific that, they're not hiring a certain amount. It's not think for a, protected group or something like that. So there's not unintended consequences on that specifically. But, as long, that I think we're gonna have to redo this one because I kind of forgot my question for that as well.
Okay, wow, thank you for that information. Swapnali, if we can go over to you for worker case scenarios. Let's say if a worker abroad has an approved petition, for example, but the employer now declines to pay the $100,000 fee. What happens in this situation?
I would say, like, if the beneficiary has an approved petition and if the petition has been filed before the effective date of a proclamation, there is no question of this rule being applicable to such petitions, because that is clear from USCIS guidance that any petitions which were filed prior to the effective date of a proclamation, the 100K fee rule is not applicable. So if any such beneficiary right now has any approved petition, I think he can safely apply for his visa because the fee is not applicable to him. He can safely apply for the visa at the consulate and then he can re-enter the country. The question will come when any employer is filing any new petition subsequent to the effective date of a proclamation, and when that petition is going to get approved. Now, if the person is outside the US, then certainly the proclamation is applicable and the employer has to pay the 100K fee. And I don't think that USCIS will adjudicate the petition unless and until they see the proof of 100K fee payment. So I don't think there will be a scenario a beneficiary may face where he will see that a petition is being filed for him, petition got approved, and now the employer is denying to make the payment, because post proclamation it's crystal clear that if the H-1B petition falls within the ambit of proclamation, unless and until the 100K fee is paid, USCIS is not going to approve the case at all. So I don't think so that this will happen where the petition is approved and then employer declining to make the payment.
Okay, got it. And can a worker apply for a national interest exemption on their own? Is that possible?
I don't think so that the beneficiary can apply it, because the petition is filed by the employer and not by the employee, because employee is always considered just as a beneficiary of the petition. So it's always on the employer to establish if he is claiming that his petition falls within the exceptions mentioned to the proclamation. The onus to prove that will lie with the employer rather than the beneficiary. And it seems to me that if the employer is claiming that he is filing his petition under the national interest waiver exemption, he needs to prove that at the time of filing the petition with the USCIS. So it's not the employee who has to prove this, but it's the employer who will have to establish that at the time of filing the petition. Maybe when any such employee will go for an visa interview, maybe the consulate officer may ask him about his job profile and may try to validate whether this job profile really falls within the national interest waiver. But the responsibility to establish that lies with the employer rather than the employee.
Can you talk about how this affects H-1B workers already in the green card process?
I don't think so. It's really going to impact them because as proclamation said that if you have any previous H-1B approvals or any petitions filed for you before, or if you have a valid issued visa, then these people should be able to get their H-1B extensions without applying this rule. So these people should be able to get their H-1B extensions done without making any payment of 100K fee. At the same time, if these green card holders, if they have the advance payroll issued to them, probably if they want to exit out the country and re-enter H-1B visa being with the dual intent, it's quite possible that instead of re-entering using their H-1B visas, they can just re-enter using their advance payroll. So I don't think this is adversely going to impact those who have their green card applications already filed and issued the advance payroll.
Perfect. Good to know. So what about for short-term projects? If an H-1B petition covers only a short-term project, does the $100,000 fee still apply here?
I would say the 100K fee is going to be applied to the H-1B petition. It is irrespective whether it is being filed for a long-term project or a short-term project. It's not project-based, it's petition-based. So if the employer cannot substantially establish that he falls within any of the exceptions applicable to the proclamation, then the 100K fee rule will certainly be applicable to those petitions. So it's not project duration based at all, the application of the fee.
Perfect. Good to know. Thank you for covering that. Jioselin, I want to go over to you and ask you about how you think this can affect competition between US and global employers. What should we expect to see here?
Well, I mean, the proclamation's really early, so things are still able to shift. But companies, we are coming up early next year on the reevaluation of H-1B cap, right? Companies make their determination if they're going to do an H-1B cap. And because this is supposed to affect new petitions, some companies may not want to do cap, so they might have to reevaluate potentially if they have companies abroad, maybe doing an L visa, or other type of visa instead of the H. So that has a possibility of having a little bit of effect on H visas within the US if those companies don't want to do that. But it does open the avenues for other visa categories if they qualify for those employees as well.
Okay, and looking at wages, what effect could this have on US wages in high demand fields?
Well, I mean, if a company and ultimately decide, not to hire individuals for H-1Bs and that happens, and of course there is a possibility of increasing, wages for, in high demand positions if they're not able to sponsor an H-1B applicant similarly. So there's a possibility of fluctuation of wages. And then potentially other unintended, consequences. But, right now it's a little bit early to see what the ultimate result will be at this moment, but there could be changes possibly.
Absolutely. We have to continue to keep an eye out. If you are interested in receiving updates, we do have a newsletter that goes out. You can sign up on our website, chug.com, and we can keep you updated on everything that's going on. So, Jioselin, one more question on this. Could this influence foreign investment in the US? What is that looking like?
Yeah, I mean, like I just mentioned earlier, there is a possibility for companies to reevaluate, whether they will be hiring, foreign talent in the same capacity. Some companies might, alternate to other visa categories, like I mentioned earlier, or potentially, just keeping their labor force abroad, which, would be a little bit, incorrectly to see just because of the, amount of work, value that, applicants in H-1B bring. So that could be really unintended, but we will see with time what ultimately the outcome will be with this for company operations and everything.
Absolutely, great points there. Swapnali, I want to get into alternative solutions with you. So, do you think employers will seek more cap-exempt opportunities through universities or nonprofits?
I would have loved to answer this question, yes. But unfortunately, I don't think I'll be able to say yes to this question because USCIS proclamation, President's proclamation hasn't made any distinction between the cap subjected petitions and cap exempt employers. There is no such distinction made. The rule is applicable irrespective whether you are a cap subject employer or whether you are a cap exempt employer. So I would think that if the non-profit organizations or universities, if now they want to hire any new H-1B employees, I'm not sure if these type of organizations will be able to pay such an exorbitant fee just to have someone on H-1B. So I don't think there will be a surge in these type of cases unless and until there is a guidance from USCIS which makes it clear that any such cap exempt employers H-1B petitions are not subjected to the or to this proclamation. Unless and until we get this type of guidance, I don't think there will be a surge in cap exempt petitions.
Okay, and how practical is shifting employees to remote work abroad while keeping them on US payroll?
Um, I mean, that is doable, but again, it involves a lot many compliances, maybe the taxation, the labor laws of the foreign country, and I don't know how feasible it is even for employers to do that. Instead, I feel that there is a possibility that the work might be shifted. So the US employers may start outsourcing rather than paying the employees who are working remotely and paying them in US dollars. Instead of that, there is a possibility that US employers may start outsourcing the work to foreign workers and may let them work remotely. But we have to see how it goes and whether there is an increase in outsourcing of the work from US employers.
Definitely. So, do you think there will be a demand for other visa categories, maybe a surge in other categories if employers move away from H-1B?
Yeah, that is quite possible because if the small employers can no more file for H-1B, definitely they will look around for other visa categories, maybe L1s or TNs or E3s. So definitely employers will look around for some other work visas, and we can see that as well. If the employers end up paying 100K fee. I think this will happen more with small employers who can't afford probably paying 100K fee just to bring one H-1B employee from abroad. So certainly they will look for some other work visa holders.
Absolutely. And if you are watching this and have questions about the other visas available, please reach out to us. We would love to give you some guidance there. Thank you so much, Swapnali, for covering that. Jioselin, I want to look into the future a little bit. Let's say litigation delays the proclamation. How would you say employers should respond to this?
I think the main thing employers should be, of course, is, speaking to their immigration attorneys just to see what the litigation is specifically talking about. So, litigations get the in different stage and for different reasons. But of course, they should always make sure to strategize with their fellow immigration attorney just to make sure that, at the time that they're filing or, they're about to file to see what the status of the proclamation is. If there has been no litigation, then they have to make sure that, they do, if they have to submit that 100,000 K, that they do submit it properly so it's not rejected. But if it's not for some reason, if it's paused, then of course, follow that policy and have proof that they submitted at the proper time with the proper fees so that there's no issues. But realistically, it's always make sure to be well informed so that they make the correct decisions for the thing. But of course, prepare strategically, don't just really just depend on litigation will happen. We don't know what's going to happen ultimately. So if they are able to file now and they don't, they're one of the groups that are exempt from the proclamation, then to make sure you submit it the earlier the better, so you don't know what other change will come. So basically that's the main thing. The information point is the most important thing so that you make sure you're strategizing correctly with your H-1B petition.
Great advice there. And what lessons would you say can be learned from prior immigration proclamations?
Yeah, I mean, we've learned quite a lot from previous proclamations. Sometimes proclamations get issued quite swiftly, and then, we're trying to really decipher specifically if, if that employer is being affected by that proclamation and see what the end result is. And then ultimately, if there's litigation, we would have to revert back to the originality of what the process was like. So, like I just said earlier, it's very important to have, any employer or any company be very well informed to see what the process is like, from that proclamation, because we see all these changes consistently. When the proclamation goes to litigation, it kind of confuses some companies or employers. So, just learning from that things could change from one day to the other, and make sure you're strategizing correctly with your immigration attorney or professional, so that you're very well equipped and, filing things correctly, make sure you're in compliance. So that is very, very important.
Absolutely. Thank you so much, Jioselin, for taking the time to answer all our questions. Thank you so much, Swapnali, as well. We appreciate both of you joining us last minute for this live. Thank you, everybody, for tuning in. That is all we have time for today. Please join us back tomorrow for our fourth day of the live on this topic. We will be live at 8 a.m. Pacific time, 11 a.m. Eastern time to continue the conversation. If you have any questions, please feel free to submit them at info@chuk.com. Join us back here tomorrow. And make sure to stay tuned for our new webinars next week as well. We will be live on our regular Thursdays as well, continuing that. So please join us for that. Any questions or comments, email us anytime at info@chuk.com. We will see you back tomorrow. Thank you, everyone.
Thank you.
Thank you.